Hello, everyone. Depending on where you are in the country, I would like to wish you all a good morning or a good afternoon. Thank you very much for joining us for today's session of our monthly legal updates for Canadian employers series. My name is Catherine Coulter. I'm the group lead of our employment and labor team in our Ottawa office, and I'm thrilled to be joined today by some of my colleagues from across Canada. We've got Andy Pushalik, a partner in our Toronto office and our national employment group practice leader. Jennifer Thompson, who will be speaking with Andy. She's a partner and the group lead in our Calgary office. Stephanie Lewis, counsel in our Ottawa office, who sits right next door to me and who is one of our firm's top workplace investigators. Julia Dales, a senior associate in our Ottawa office and just down the hall from me, who's one of our firm's experts on accessibility legislation across the country. And last but definitely not least, Larissa Workowicz, our Jill of all trades expert, as I like to call her, on virtually every single aspect of employment and labor law, both federally and provincially, a senior associate in our Toronto office as well. As a reminder, today's session has been specifically curated for federally regulated employers. Most of you are going to know who you are, right? Organizations such as banks, telecoms, and rail and airline companies. There are other companies that are federally regulated, and sometimes it's a little bit more difficult to pinpoint who they are. For anyone that's listening in today and is not actually sure whether their company is federally or provincially regulated, please do feel free to speak out, to reach out after the webinar to any one of the speakers. Today's speakers are part of a specialized group of experts within our national employment law team, and they work frequently with federally regulated employers and are specialists when it comes to the needs of those companies. We're going to start today's session talking about Canada Labour Code updates and compliance, which is going to feature both Andy Pushalik and Jennifer Thompson. Like my colleague Stephanie, who's speaking today, I like to share fun facts about my speakers, my colleagues, because everybody's lots of fun. All the better to get to know us, and it makes a review of dry legislation sometimes a little bit more fun as well. And so with that, here are my fun facts about Andy and Jennifer. Andy's fun fact, which I didn't know until this morning, is that he is very superstitious. So don't be walking around under any ladders with a black cat nearby if Andy is around. As for Jennifer, she tells me that she lived in Germany for 5 years, but has to confess that her German is terrible because she lived in Bavaria and all the locals speak Bavarian. But I'd be willing to bet that she knows her way around an Oktoberfest or two. With that, over to you, Andy and Jennifer.
Hi, good morning from a rather cold and wet Calgary. We are definitely not the blue sky city this morning. So hopefully your weather is better than ours. So I'm going to start off with a bit of an update on legislation, on Canada Labour Code updates and others. The first one is important if you have contractors in your organization, because Bill C15, which came into effect in March of this year, allows the Canada Revenue Agency and Employment and Social Development Canada to share information with each other to try to combat misclassification of contractors as employees. Now, particularly for those in the trucking and transportation industry, you will be interested to know that the CRA has indicated that you are top of their list for looking into on-contractor compliance. So I would really recommend that you do review what you're doing with contractors to make sure you are in compliance. There may be penalties, but to be honest, the main issue is going to be that it's going to put you under the spotlight for CRA, and they may then audit your wider operations, which is no fun. So that's just something to be aware of. There have also been some updates to the bereavement leave provisions in the Canada Labour Code. These mainly relate to pregnancy loss and loss of a child. So going forward from December of last year, there's now a new pregnancy loss leave of up to 8 weeks for stillbirths that happen after 20 weeks of pregnancy, and up to 3 days for other pregnancy loss. This also includes surrogacy arrangements. The first 3 days of those leaves are paid as long as employees have been employed with you for more than 3 months. There's also an expanded bereavement leave of up to 8 weeks for loss of a child. For all of these new bereavement leaves, they've also expanded the protections for people on these leaves so that they now reflect the protections in place for other longer term leaves of absence. So that includes the right of reinstatement to a similar or comparable position, the right to receive information about job opportunities while they're on leave, continued accrual of benefits and seniority, and protection from reprisals. This is all being then supported as well by enhanced compliance requirements in terms of record keeping of being on those leaves, and also making sure that there's a notice in the workplace letting people know that those leaves now exist. And as always, there's penalties for non-compliance. So good to be aware of what's going on that front. So that was a quick roundup of the latest things. So I'm now going to pass it over to Andy to give an update on termination provisions, which he's very au fait with because of being in Ontario, where these things change all the time. So.
Great, thanks, Jennifer. And this case is a good example of Ontario's kind of poisonous termination clause case law that seems to be infecting the rest of the country and other jurisdictions. And so in this case, two bank employees had filed a claim alleging that their termination provisions were unenforceable. So it was two employees, they're in the same position, and the contracts were identical. Their argument that the provision was unenforceable was based on two different kind of lines of thought. The first was that the without cause termination provision had the language that you could terminate the employee's employment at any time. And in Ontario, there's been a line of case law that's now on reserve at the Court of Appeal as to whether or not that language should be held enforceable. At present time, the lower court ruled in Ontario that that is not compliant with the Employment Standards Act because there are moments in time where you can't actually terminate an employee's employment. For example, if they are coming in off of a statutory protected leave of absence, or if there's a reprisal situation. And so the lawyers in this case had advanced the same argument based on the same types of protections that are under the Canada Labour Code. The other line of argument was based on cause. And in this contract, the contractual provision defined cause. You see it there on the screen. It used includes, but is not limited to. And so if we look at kind of what happens in this case on the next slide, the judge accepted that the for cause provision was unenforceable. And in Ontario, under the Provincial Employment Standards Act, there is this notion of willful misconduct. And willful misconduct is being bad on purpose. It is something that allows the employer to avoid having to pay any sort of termination pay, statutory or otherwise. The judge noted that under the federal system, for federally regulated employees, we're not looking at willful misconduct. We're looking at just cause. I think this is really reading the clause pretty closely. The judge said, well, look, all you've got is this for cause provision. You don't actually define what cause is as related to just cause. So by not including the just cause phrasing, the judge was already not on board with this provision. The judge then went on to note that in these types of clauses, which are very common for a lot of employers, where they try to list examples of the type of subconduct which would warrant a summary dismissal, the judge said, well, this won't actually amount to just cause in all circumstances. You need to take a contextual approach. And so on that basis, this for cause provision is offside of the Canada Labour Code, and then struck the clause down based on that. The judge then did spend quite a bit of time and providing an analysis of the Ontario case law on the without cause termination provision and the anytime language. And I mean, if you read the decision, it's quite clear that the judge would have found that without cause termination provision was not going to be enforceable. However, given that the judge had decided that the just cause provision didn't work, that was sufficient for the judge to kind of end the decision on that point. So we don't actually have a decision, at least in this case, about the enforceability of the without cause termination provision. There are some other arguments about whether a savings clause could rehabilitate this termination provision. In Ontario, that those types of clauses have been struck down. The judge in this case applied the same type of logic in this particular instance. So the savings provision, the judge said, look, that's really if there's a change in legislation, but it's not to rehabilitate an otherwise unenforceable clause. So where this case then ends up, in case you're interested, the one employee 5 years of service, 38 years old, making around $50,000 as a non-managerial employee. That employee got 7 months notice. The other employee, she was 54, 6 years of service, same position, and got 12 months. So you can also see that really not a lot of rhyme or reason as to how we're getting to these notice periods. The second notice period, I think, is particularly high. So in terms of a takeaway for all of you who are listening, it just remains to look at those termination provisions. And now I think we want to get rid of the long list of what constitutes cause and make sure that you're being very, very stringent in the types of phrasing that you're using. We're keeping a very close eye on the Ontario Court of Appeal. We expect that there's going to be a decision, I would think potentially by the end of the summer or early fall on the anytime language, and that's going to affect employers in Ontario and the federal regime, and quite frankly, across Canada, as it seems as though the Ontario case law, like I said at the outset, is really seeping into other jurisdictions. So I'll hand it back over to Jennifer for another quick case summary.
Thanks, Andy. So this case is a case where a former employee of TD Bank filed an unjust dismissal claim under Section 240 of the Canada Labour Code, claiming that she had been constructively dismissed because of harassment on the basis of age and race. So she filed that complaint. The CIRB declined jurisdiction on the basis that the correct forum was the Canadian Human Rights Commission. So kind of makes sense, because it's the kind of claim that you if they'd filed it in the Canadian Human Rights Commission, it wouldn't have surprised you based on the subject matter. The employee was obviously unhappy about this and filed a judicial review application with the Federal Court of Appeal. That the Federal Court of Appeal dismissed the application, and the basis for that was because the Canada Labour Code includes a provision that says that the Industrial Relations Board will not consider an unjust dismissal complaint if a procedure for redress has been provided elsewhere in the Canada Labour Code or in other legislation. So the Federal Court upheld the fact that it should be the Canadian Human Rights Commission and Tribunal that looks at this, unless they refer it back to the Canadian Industrial Relations Board. So, and that holds even though the employee had not filed a Canadian Human Rights Tribunal complaint and was now out of time. That didn't make any difference. It was up to them to kind of file it in the correct place. So the Federal Court of Appeal did comment on remedies, because that was the real push of why this employee wanted it in a different forum, because she felt that the remedies would be better under the unjust dismissal regime. They said that, yeah, the remedies are not the same, but they're similar enough. So that's not a reason for allowing her to go into a different forum. So I think in terms of a takeaway, if you do get a unjust dismissal complaint that looks like it could be a human rights complaint in disguise, then it's worthwhile trying to raise a preliminary objection to that to try to get it punted out on that basis. So I'm going to pass this back to Catherine now.
Thanks, Jennifer, and thanks, Andy. Our next session is on employee relations and workplace investigations, featuring my colleague Stephanie. I think Stephanie probably has, hands down, the best fun fact of the year. She and her husband Andy are in the middle of a basement renovation at the moment, and when they're done, at Steph's request, they're going to have a speakeasy in their home, hidden behind a bookshelf. My view is we can all give up right now. Nobody is ever going to have a home that is that cool. Over to you, Stephanie.
Thanks, Catherine. Hi, everybody. It's nice to be here with you today. We have a lot to get through, so let's just jump right on in. This is what's up. This is the agenda. We're going to start with a note on employee relations and workplace investigations. Then we're going to move into a review of a recent decision that's got delicious law in it on investigations and findings related to workplace sexual harassment. And then finally, if we have time, we're going to get into a review of procedural fairness decisions. And don't worry if we don't have time, I have a plan. So now we're going to move right into it. Note on employee relations. So we know that under the current version of the workplace harassment and violence prevention regulations, there is no pull the chute mechanism for if you get a complaint that on its face doesn't meet the definition of harassment. If someone makes that complaint and they go through either negotiated resolution, and they either go through negotiated resolution, they still don't agree that it wasn't harassment. They try conciliation. They try the other methods and they still don't agree. They can force a workplace investigation. There's no way around it at present, but there is. Not from a legislative perspective, but the suggestion that we're making is that even if in the workplace things don't on their face amount to harassment, if you notice resentments building amongst employees, have managers actively manage. And I appreciate that that can be a tricky road to hoe. Like it can be a tough thing to decide when it's time to intervene and when it isn't, because our managers are very busy managing all kinds of things. But what we see a lot is smaller perceived slights. So somebody is coming into the workplace and they don't say hello to somebody one day, but they say hello to everybody else. And then the rest of the week goes by, and for whatever reason that may not be intentional, they don't say hello to this person. Then you add in something performance management wise that has a legitimate performance management reason that the person may not understand. So we're adding and we're adding, and the resentment builds, and eventually something happens where you get a complaint, and then we're stuck. Then if somebody can't negotiate resolution, can't conciliate, then there's an investigation that's coming, irrespective of whether or not on its face it meets the definition of harassment or sexual harassment or workplace violence. So if we're actively managing and we jump in early, we can head this off at the pass where possible. And that's just a note. We can unpack that further if people have more questions, but I really want to get to our next case. So we're going to move right in, friends. So this decision is a decision where the employer did everything right and they got a silly decision at the tribunal level. It has a mostly happy ending, which I have thoughts on, but this is a story that warrants telling. So the background facts here. We've got the respondent is a long service employee. He's been with the employer for 23 years. He's got a clean disciplinary record. He and his coworkers work in a close-knit department, and they share details of their family lives. They're tight. The complainant joins the group, and the whisper network is popping off. They are telling her, look out for this guy. He's going to say weird stuff. I don't actually know what they're telling her, but they reference the fact that she's warned when they join. Now, let's go on to what the allegations are, which are on the next slide. Okay. So the allegations are that he makes comments and questions about, he makes comments and asks questions to his colleagues about their sexual development, their children's sexual development, and he makes comments about his own children's sexual development in the workplace. He's also alleged to have made a comment about the size of the complainant's breasts. And finally, there's a discussion where he has with them about, he's talking about showering with his daughters when they were younger, and people are feeling weird. And a quick note before we get into the meat on this case, there should be a decision tree, right? About when it's okay to make a comment about someone's breasts in the workplace. Are you a medical professional? Mammograms are an important diagnostic tool. Answers no. Are you a photographer of swimsuit models? Still no. Are you investigating workplace harassment allegations as an investigator? Still no. Then you shouldn't be making comments about people's breasts in the workplace. And for people right now who are spending time thinking about other examples where that would be okay, I can tell you right now, my response to you will be the exception proves the rule. No breasts in the workplace. No breast chat in the workplace. So the complainant here who is one of his colleagues who joined the group, and the Whisper Network was looking out for her, complained to her manager after a troubling conversation with the respondent. And during that conversation, he described his daughter's sexual development and commented on her body. So she's feeling weird. She goes to the manager, and the manager refers it to the people department. Good job, manager. You know what's up. Then that leads to a formal harassment complaint against the respondent, and that harassment complaint is investigated. Look at the employer killing it at every step. Investigated, and the investigators conclude at the end of their investigative process that the respondent had solicited information from his colleagues about their sexual development and their children's sexual development. We're not there yet. Move back. He asked female colleagues intrusive and inappropriate questions of a sexual nature. He shared an inappropriate level of detail regarding the intimate details of his family dynamic. He demonstrated physical intimidation and aggressive body language and posturing, and he retaliated against his female colleagues. So guess where this ends up? The employer gets the results of the workplace investigation, and the respondent gets fired. He gets fired for having engaged in harassment and sexual harassment and for the failure to follow employer policies. Makes sense, right? Next slide, please. Okay, so then we go to the Canada Industrial Relations Board, and we're just going to call them the board for the balance of this presentation. And I have thoughts about this decision. Juicy, juicy thoughts. So the CIRB, the board, finds that the respondent did solicit information from female colleagues on their sexual development and the sexual development of their female children. He did that. They find that he asked female colleagues intrusive and inappropriate questions of a sexual nature. That happened. Finds that he shared an inappropriate level of detail within the workplace regarding the intimate details of his family dynamic. So all of this is found to have happened. And the adjudicator finds that the respondent's behavior created an uncomfortable and unwelcoming environment and was inappropriate in the workplace. But I hope you're all sitting down and holding onto your hats. Next slide, please. Despite the findings, the board concluded that it wasn't sexual harassment. The board found that the respondent's questioning and interactions upset various people, but he didn't know or appreciate the boundaries. It wasn't because he was engaging in harassment. So for those of you right now who are thinking of the definition of sexual harassment and you're floored, don't worry, we'll get there in a second. They also found that while he had engaged in aggressive behavior, as described by his colleagues, it wasn't serious enough to warrant termination. Now, they did consider some mitigating factors. He was a long service employee, as discussed in our background facts. He had 23 years, he had a clean disciplinary history. He also gave evidence about suffering from mental health issues. So the board finds that it was too extreme to terminate his employment. He ought to have been given a 5-day suspension. There are interesting comments about the context that led to the adjudicator making these findings at paragraph 14 of the decision that I would encourage you to read. Now, for those of you who have lost faith in humanity and on people's ability to apply the law as it exists today, don't worry, the federal court has got you. Next slide, please. Thank goodness for the federal court. Goes to the federal court, and the federal court finds that the board's determination that it wasn't sexual harassment was unreasonable for a couple of reasons. First, it was logically flawed because at one point the board finds that the behavior was sexual in nature, and then later in the decision, the adjudicator finds that none of the respondents' comments were sexual in nature or intent. And I want you to hold on to intent, which we're going to get to later in this slide. Then the second reason that they find it was unreasonable is that the respondents' comments and questions to his colleagues, the findings about those contradicts the case law on sexual harassment. So those of you who are thinking Jansen and Plady, you're right. Those of you who are thinking this totally fundamentally underlines my understanding of the law on sexual harassment, you are correct. And so is the Federal Court of Appeal. And that the respondents' comments were sexual in nature. They were made repeatedly, and he knew or ought to have known they were inappropriate and unwelcome. It was sexual harassment. And then they get into the fact that sexual harassment is objective. And this is the key point, right? It doesn't require that the maker of the comments appreciate that they're inappropriate or that they're or that the person to whom they are directed object to them. They don't have to know that they're objectable. They don't have to know that they're offensive. It's a matter of when viewed objectively, are they of a sexual nature and offensive? So we get through all of this, and we're at a point where the FCA sets aside the decision, so don't be too happy yet, because it makes sense that the decision gets set aside, but it's going back to the same adjudicator for redetermination in line with the fact that it was sexual harassment. So I think we know where this is going to go. It's going to go back to the same adjudicator. The same adjudicator is going to say, okay, fine, it was sexual harassment, but I'm going to still apply the mitigating factors, and the result is still going to be a 5-day suspension. What really I may take issue with here is the aggressive behavior beyond The comments, okay, maybe he didn't understand them. Maybe we can correct that behavior. But beyond that, he punched his fist on the table and he engaged in retaliatory conduct. This is somebody who's, in my view, probably not great to have in the workplace. So sending it back to the same adjudicator who's already clearly communicated that they're not of a view that the behavior is serious enough to warrant termination, I don't think we're going to get the full happy ending that we need here, but at least we have the Federal Court of Appeal on our side in managing this. Next slide, please. Okay, so we're going to do a 30-second debrief on procedural fairness. We know that Marintet is the first decision after the new regs came in 2021 to address the need to have a respondent party review contradictory evidence that was put up and conflicts with what they've said prior to the finalizing of a report. In that case, the employer had a checklist in their workplace violence harassment prevention documents that indicated that the individual would get an opportunity to review the preliminary report. If it's a policy that says it, we know that you're going to be held to that policy. So that's perhaps unsurprising. They refer back to Provenose, which was a decision prior to the new regs, but this is the first decision post new regs. Brown, after Marintet, applies Marintet and says in every circumstance, a complainant should have the opportunity to review the preliminary report. Now, notes on this, preliminary report is not defined in either decision. So what does this contain? Now, for those of you thinking what I thought as a neutral third-party workplace investigator and regular lawyer who practices in the federally regulated sphere, how is this leading to a neutral and unbiased third-party investigation if somebody is given a copy of a report and ability to comment on the findings and the recommendations before it goes? That's improper. For those of you that are not loving that, read Caro. It will largely make you happy. It says that yes, contradictory information should be put to them in one way or another, but it says commenting on the findings and on the recommendations is inappropriate. Deputy Justice Phillips or Associate Judge Phillips really knocked it out of the park there. There's an interesting commentary about the engagement that is expected from managerial employees that I think might not be great and maybe warrants a further decision later, but that gets us to time. And with that, I would like to pass it back to my wonderful colleague, Catherine.
Thanks, Stephanie. Our next speaker is Larissa, who will be discussing emerging issues in federal workplaces. Larissa's fun fact is that she has been to both the most northerly capital in the world, which I didn't know until yesterday was Reykjavik, as well as the most southerly capital in the world, Wellington, New Zealand. I'm envious. Over to you, Larissa.
Thank you very much, Catherine. And so up to now, we've heard a lot about changes that have happened to date. What are the developments in the law? What's been amended to the Canada Labour Code? What about the future? What is at the forefront of the labor program's mind? What about employers? What are they battling with? That is what I am here to talk to you about today. And so if we go to the next slide, we can divide these emerging future issues into three broad buckets. The first, evolving workplace expectations. Now, there's a lot of things that I could talk about here. Probably could just have a whole webinar on that myself, but I'm limited in what I can talk about today. So I'm going to focus on three topics: the battle of the return to office, the looming right to disconnect policy that is still not enforced, but it's coming, and recently announced proposal on banning non-competition clauses from employment agreements in for federally regulated employers. We'll then shift to the next bucket, which is artificial intelligence, the million-dollar word and topic that everyone has on their minds these days. And then finally, we'll talk about administrative burdens. And for those of you scratching your heads, I'm going to just keep you in suspense for now. Stay tuned for the next 11 minutes, and you'll find out what I mean by that. So if we move on to the first topic, battle of return to the office, it feels like every month there's a new announcement about a workplace that is increasing in-office attendance requirements. And the most significant announcement that we've seen recently comes from the federal government themselves. They have mandated an increased in-office presence for staff, a 5-day requirement that came into effect May 4th, 2026. And all other employees are going to be required to attend 4 days a week as of July 6th, 2026. Now, this is not surprising. This is a trend that we're seeing across all different industries, all different sectors. And if done correctly, this is, of course, something that an employer can do. And the context on how to do it correctly will matter. that will determine whether or not an employer can or can't make these changes, or how quickly an employer can do that. And again, we could spend hours talking about this, so I don't want to focus on that. What I did want to touch on this topic is section 177.1 of the Canada Labour Code. Now, this is a clause that came into effect in 2019. So before the infamous pandemic that actually brought remote work and hybrid work to the forefront of everyone's mind. But through this clause, there was a mechanism introduced in the Canada Labour Code through which employees with 6 or more months of continuous service could request flexible work arrangements relating to either the number of hours they're working, their work schedule, or the work location. Now, requests have to be made in writing. There's prescribed information that has to be included: name, the date of the request, the description of the requested arrangement, the start and end date of the arrangement, and the expected effect on the employer. And then after an employer receives that request, they have 30 days to respond and provide one of 4 responses: either approval as requested, approval in part, a counter or a proposed alternative flexible work arrangement, or just a straight up denial. And if the employer is denying the request, you have to provide a justification. And there's a lot of examples on the Labour Program's website of what are acceptable justifications. The change would result in additional costs that would burden the employer. It would have a negative impact on the quality or quantity of work, ability to meet customer demand, performance of the workplace itself. It would require hiring of more employees. There wouldn't be enough work available for other people. Those are examples of the types of things that are reasons that the Labour Program has said can be acceptable. And I raise those examples because there is a distinction between a request for a flexible work arrangement under the Canada Labour Code and a request for an accommodation under the Canadian Human Rights Act on the basis of a protected ground. The latter has a different process. There are different types of reasons and analysis that will go into assessing whether that accommodation has to be provided. But I'm not here to talk about that. I really just wanted to put section 177.1 back in the minds of federally regulated employers as you may face, decisions around the return to office, and in particular, resistance to in-office attendance requirements. Turning now to the next bucket, the proposed right to disconnect policy. Frequent listeners of this webinar series will note that this is probably my 3rd or 4th time talking about this policy, and that's because the federal government just keeps delaying things. For those of you who aren't listeners, haven't had to hear my talk before, what am I talking about? The federal government has introduced legislation that would require federally regulated employers to develop a policy containing rules and expectations regarding work-related communication outside of scheduled working hours. So it would impose and create that right to disconnect. And that's important because that's actually how it's phrased in the code, unlike Ontario, which has a disconnecting from work policy slightly distinguishable. Now, this legislation is still not in force. We don't have a timeline yet on when it's expected. Earlier in the year, the Labour Program's regulatory plan for 2024 to 2027 had suggested that the targeted coming into force date was this year, 2026. But if you look at the updated regulatory plan for 2026 to 2028, there is no longer a mention of a targeted coming into force date. So stay tuned. Once this does come into effect, employers will have 1 year to bring themselves into compliance and to develop their policy. And of course, we anticipate more information will become available when that announcement is made. Finally, turning to the more recently headline-grabbing news, Bill C-31 and the proposed prohibition on non-competition restrictions. Now, my colleague Camille Paradis-Loisel and we just did a client bulletin on this change, so I'm not going to spend too much time talking about that. We'll share a link to the bulletin in the chat. But just at a high level, if passed, this legislation is going to impose an outright prohibition on non-competition clauses for federally regulated employers. And actually not just non-competition clauses, but also employment-related restrictions, which has not been defined or particularized, so we don't really know what that means. But this prohibition on non-competition clauses, as well as other employment-related restrictions, it's not all encompassing. There are some exceptions contemplated, and anyone who's familiar with Ontario's restriction, Ontario being currently the only jurisdiction that has a ban like this, these will not be that surprising to you. Limited transactional circumstances where a person is selling their business and then becomes an employee, that would be one exemption. Employees who perform the function of the chief executive officer, or employees who hold other executive positions, including other chief executive roles, and report into the CEO, those would be exemptions. Now, notably and different from Ontario, existing non-competition clauses would not be preserved. And Bill C-31 contemplates a 1-year transition period from the coming into force date when employers can come into compliance, after which any existing non-competition clauses will be rendered void or null. So that is something to keep an eye on the horizon. We will, of course, be monitoring. We'll provide more information as we get updates on when this might be coming into force. Now let's move on to everyone's favorite topic right now, artificial intelligence. Now, there's no concrete development yet on this topic, nothing I can talk about in terms of proposed legislation or impact on the workplace, but it's clearly on the mind of the federal government. We've seen an AI for all national artificial intelligence strategy published by the government. It's available online, talks about the 6 pillars that form this strategy, one of which is the need to protect Canadians from the risks and harms of artificial intelligence. And within that, there's an explicit reference to the questions and issues that AI is raising about job security and privacy. So I do think legislation is likely in the future. We just don't know what that would look like yet. But we may have a bit of a preview. In April of 2026, the federal government, and specifically the Labour program, launched a consultation on modernizing the labor relations framework under the Canada Labour Code. And one of the topics under that consultation document is exploring training support for workers impacted by automation and artificial intelligence. So through this consultation, the Labour program is looking at how workers might be impacted by artificial intelligence. What are the barriers that they might face in training programs that would cause that sort of an impact? Are there training needs that could be established that could better allow adaptation to changing industries? And also, how could training programs maybe enhance collective bargaining? So this is still very early stages, but it might be a signal of where the federal government might go on AI legislation. Finally, now what you've all been waiting for, administrative burdens. Now, this is a little nugget that I found when I was looking at that federal forward regulatory plan for 2026 to 2028. And what has been proposed, or the objective of this proposed initiative, is to clarify and simplify record keeping and reporting requirements under the Canada Labour Code to reduce administrative burden and red tape on federally regulated employers, and to update any obsolete provisions under the Canada Labour Code. Now, that's all we know at this time, but the federal government has announced that it's considering amendments that would address each of these different objectives. And regulations are expected to be published in 2027. So we have a bit of time. And I think until then, we're all just going to be left trying to solve the Rubik's Cube of the Canada Labour Code to figure out what these obsolete provisions could be. I think all of us could guess at least a couple of them. But with that, I'll leave everyone in suspense and turn things back over to Catherine.
Thank you, Larissa. Our final speaker today is Julia. She'll be discussing accessibility under the Accessible Canada Act. I should add here that accessibility, like pay equity and employment equity, is a requirement on federally regulated employers that I find is oftentimes overlooked. But, if you're not aware, you need to be aware that there is federal legislation in all 3 areas that governs companies in the federally regulated sector. And there are a significant amount of legislative requirements under all 3 pieces of legislation, including public reporting, often annual public reporting in relation to compliance with those pieces of legislation. If any of this happens to be news to any of you, please reach out to Julia for accessibility advice, or to either myself or Larissa for employment equity advice. Julia's fun fact is that just last month, she did the Salkantay trek. I hope I pronounced it correctly. That's the trek that goes to Machu Picchu in Peru. It's a really difficult trek at very high altitude. I've taken the train. I wouldn't dream of having trekked that, but Julia says that she did it and that it was one of the best trips in her life, and she highly recommends it. Over to you, Julia.
Thank you, Catherine. So accessibility has been part of federally regulated organizations' requirements for a little while now. The Accessible Canada Act came into force in 2019. The purpose of the act was to remove barriers to individuals with disabilities throughout all aspects of Canadian society by 2040. And so the obligations under the Act are not just limited to employment. And the obligations that have been in effect since 2019 are ongoing. So most federally regulated organizations will already be doing these things, should be already be doing these things. And like Catherine said, if you're not, then please do reach out to us. I'm going to talk about what those obligations are, but also what is coming next under the Accessible Canada Act. For provincially regulated organizations, you might have heard of the AODA, for example. That's the provincial accessibility legislation, which applies in the provinces where it exists. If you're federally regulated, though, then it's the Accessible Canada Act. So we'll move along. The way that the ACA works is that it sets out different areas in Canadian society where we want to identify, remove, and prevent barriers to individuals with disabilities so that they can participate equally. So these areas include employment, but also include information and communications, the way that we provide goods and services, etc. Next slide, please. So the way that the Act is intended to work is that within these areas, there will be obligations that are specific on organization in terms of how they provide goods and services in accessible ways and how their information and communication is provided in accessible ways. However, for now, the ACA is pretty bare bones. The requirements are limited to accessibility planning, feedback on the planning, and progress reporting on the plans. So those are the general requirements that exist now for federally regulated organizations, but there are new requirements coming that we'll talk about. And additionally, each phase of the planning, accessibility planning, feedback, and progress reporting I'll talk about also is done in consultation with persons with disabilities. So we'll move along to go into detail on these. The regulations under the ACA operationalize the deadlines and specifics about requirements for accessibility planning. For most federally regulated organizations, the Accessible Canada regulations govern those rules. However, for transportation, broadcasting, and telecom entities, those are governed by their own individual regulations. Generally, the obligations, the core ones, are the same. There are just nuances in terms of deadlines and who your reporting goes to. Next slide, please. In terms of deadlines, the initial deadline for publishing accessibility plans has already passed. It was in 2022 for large organizations and 2023 for small organizations. Organizations with less than 10 employees do not have these reporting and publishing obligations. The way that the Act worked is there essentially is a 3-year cycle. So you publish your plan. In the next year, you publish a progress report on how the plan is going. The following year, you publish another progress report. So that's your 3rd year. And then the 4th year, you publish an updated accessibility plan. And that continues onwards. And so I've just set out considerations with respect to deadlines on this slide. And each time that the plan is published or a progress report is published, then there's notification requirements to the applicable entity, whether you're a federally regulated organization or a broadcast, telecom, or transport organization, your reporting will go to specific entities. Generally, organizations notify the Accessibility Commissioner. So I'll move along and talk about what actually goes into an accessibility plan. Like I said, it's fairly bare bones. The required information right now is limited. There's mandatory headings that are in your accessibility plan. So the first one's general, and under that you have to identify who at your organization is responsible for implementing the accessibility plan, receiving feedback from individuals on the plan and barriers to the plan, and then as well, you need to include contact information for individuals to communicate. And then the other mandatory headings are the Section 5 headings. So these are the areas that are applicable to your organization. So it may not be transportation, but likely employment, likely information and communication. And within those areas, you're required to identify your policies, programs about how you're going to identify, prevent, and remove barriers to individuals with disabilities. Then you include actions you plan to take to address those barriers and training provided to employees. At the moment, there's no required training. The plan requires you to address whether there will be training. Then under the third mandatory heading, consultations, you're going to explain how you consulted with individuals with disabilities to create the plan. So again, these are limited requirements, and it's really at the discretion of the organization to do its own analysis into its areas where there could be barriers and what it plans to do to remove them. It's really putting the impetus on the organizations until we have more fleshed out standards. Next slide, please. So on the next two slides, which I'll just skip over, I've set out the requirements that go into the feedback process and the progress reporting. So we'll skip ahead through this. And we'll also skip this slide. Perfect. Okay. So I'm skipping those because hopefully most organizations are already doing those things. And like I said, there's a 3-year cycle that you follow in terms of doing your progress reports. However, just general requirements that apply to both the plan and progress reports, they must be published in an accessible format. So that is the web content accessibility guidelines. So the WCAG level AA is the standard for those. Then the plan and the reports have to be published on your website, or if you don't have one, then displayed in print at your location of business. Additionally, if individuals request your accessibility plans or your progress reports in an accessible manner, like print or braille, then it must be provided, and there's set deadlines for when those are provided, which I've set out on this slide. And we'll move on to the next slide, please. So like I said, the current obligations under the ACA and the regulations are limited around having your accessibility plans, having a feedback process, and reporting. Those are the core obligations. However, the intent, like I said, is that standards within the areas listed in the Act, like employment and information and technology, are going to be fleshed out over coming years. And the first example of this is the information and communication technologies area. So there are amendments to the Accessible Canada regulations that are coming into force for medium and large organizations that will be required to comply with this standard that was adopted in Canada by the Accessibility Standards Canada to comply with digital technology accessibility requirements. So these requirements include ensuring that new or updated digital content meets the ICT standard, which is that European standard I'm talking about. That includes WCAG 2.1 level AA compliance. Also, requirements to publish accessibility statements specifically about digital technologies, providing training to employees about digital accessibility if they're involved in developing and maintaining and procuring digital technologies. And then conformity assessments if your technology is not meeting those standards. These obligations do not apply to all organizations. It is size dependent. And Organizations with 99 or fewer employees are completely exempt. So small organizations will not have to comply with the new digital technologies regulations, which is not the formal name, but that's how accessibility standards Canada is referring to them. We'll go to the next slide, please. So a deadline to keep in mind for medium and large organizations is December 5th, 2027, because that's when training will be required for employees involved in developing, maintaining, or purchasing digital technologies. And that training needs to be refreshed every 3 years. Then the purpose is that training will be used for employees to help organizations comply with the remaining obligations under these regs. So by December 5th, 2028, further obligations will come into force, which will include having your new and updated web content be compliant with the ICT standard, and further obligations which depend on whether the content is employee facing or not. So if you have content like intranet portals that are for use by the employee only, the requirements for those will be different than public-facing information. But you'll see that medium-sized private sector organizations have more limited obligations. They still have the training requirement. And then by 2028, it will be the compliance with the ICT standard for employee-facing and non-employee-facing web pages. Again, these apply to new or updated web content. Another point to flag is that while the ICT standard is the next up and coming amendment to the regulations, we can expect that the ACA is going to be fleshed out in the coming years to meet that 2040 deadline set out in the Act. So Accessibility Standards Canada currently has a number of standards that are published on its website. However, they are optional right now, and until they are adopted into legislation, they won't be obligatory. But those standards are really helpful to look at where this legislation is likely heading. For example, there's an employment standard that has been published, which covers accessibility through the whole life cycle of employment and involves having accessibility committees and policies. And so we can expect to see those come into force. So for next steps, recommend looking at those standards that have been published by Accessibility Canada on their website, because we can expect that that is likely where the government is going to go with regulations under the ACA. And on this last side, not to scare you all, but I've just put enforcement and penalties with respect to non-compliance with the ACA, which are fairly broad. But as a note of comfort, the regime with the ACA is not focused on penalizing. It really is trying to encourage organizations to come into compliance. And so there are options available to remedy non-compliance before you get hit with these big fines. And I will turn it back to Catherine.
Thank you, Julia. We have about 4 minutes left for 1 or 2 questions, and we do have some questions. This is for Stephanie. Stephanie, you mentioned the Carreau decision that you feel is a positive area of development with respect to procedural fairness as it relates to workplace investigations. Can you tell us a little bit more about that, please?
There we go. Coming off audio is a real challenge today. So this little response is basically a love letter to Deputy Judge Mark Phillips, because this is a circumstance that adds a little reason to what I feel has been a slippery slope in terms of the procedural fairness jurisprudence that's been developing federally. So September of 2025, this decision comes out. It relates to an investigation that was conducted in 2023, 2024. So the employer receives a complaint, they hire a neutral third-party workplace investigator. The complainant adds a number of individuals after the investigator has been retained as respondents on the grounds that they didn't do enough to step in and manage this situation and handle it the way that is required. One of the respondents, the person who's the applicant in this decision, is interviewed She then responds by providing extensive documentation. She's given a draft of her evidence, which she reviews. She's then provided with a summary of the evidence of the facts alleged against her, and she responds to that as well in the process of this workplace investigation. Come to the end of the day, on May 28th, 2024, the neutral third-party workplace investigator issues their final report. It's called final report, sends it to the employer. It's subsequently sent to the employees. Think back to Marentet. Marentet was issued on May 2nd of that year. So that's the decision that says that people have the right to comment on a preliminary report. But that was not the law at the time of this workplace investigations retainer. So the employer, trying to backtrack, then sends a note to the parties saying that they have an opportunity to comment on the final report, trying to get in line. I'm assuming they're trying to get in line with Marentet. And they go back to the neutral third-party workplace investigator, and the neutral third-party workplace investigator says, and this is a paraphrase, no. They were retained to do a neutral third-party workplace investigation. Everybody had the opportunity to comment on the controversial facts that conflicted the evidence that they gave, and so the report was fine. And the Deputy Judge Phillips agreed. And this is my favorite quote. And if I leave you with anything, I'm glad it's this. Thank you, Deputy Judge Phillips. The case law, properly understood, is in accord with the processes just described, the requirement being that the responding party know the case to be met and that he or she be able to meet it. No authority has been invoked indicating that an investigator's ultimate findings of fact, legal characterizations, conclusions, and recommendations are to be subjected to criticism from the parties with a view to them trying to influence the outcome of the investigation. And he also makes comments on how that risks making it not a neutral and independent decision. He's great. We're going to claps for him. There's also a comment in there because one of the respondents says that she was a manager. So she assumed that somebody else was dealing with it and she can't be expected to engage in all of this. And that is not what was found with the report. So it's a cautionary tale for senior individuals who become aware of harassment allegations, that if you aren't aware that proactive steps are being taken, the federal court may not agree with the fact that you're so managerial that you don't need to engage yourselves. And with that, unless anybody else has any questions or wants to talk about Capo for fun, that's about all I have to say.
Thanks, Stephanie. If you have any other questions or would like some tailored guidance in relation to today's federally regulated employer topics or any other workplace issues, don't hesitate to reach out to any one of us again. We appreciate your time. We appreciate your engagement today. We look forward to connecting again in September, and go Canada for tonight's World Cup game.